Welcome back to FARS. I'm Warnike Miller, and I'm here once again with two of my favorite all-time procurement attorneys, Mark and Bob Tepfer. And today, we are talking to you about GAO bid protests. Now, if you take a look at our historic findings here, it used to be about 10 years ago, if you had a bid protest, you had a 1 in 10% chance of going to a GAO hearing. These statistics have steadily declined over the last decade to the point that really you've got about a 1 in 50 shot of having your case go to hearing. But we want to do this because it's important. If you take a look, old school, there used to be, oh wait, you don't know, please. Remember the Muppet Show? We have our very own Statler and we're very pleased to have Bob and Michael with us. And they're going to help us understand statistics. Because if you look back another 10 years, you can see that the average hearing rate was a lot higher. It was a lot closer to 1 in 10%, 1 in 10, a 10% chance of going to hearing for quite some time. So we want to talk about what it means to go to a hearing, what you can be expecting at a hearing. And the only way to do that is to talk to some people who've been to the GAO for the GAO hearings. And that's, gentlemen, can you tell us a little bit about what we could expect called in front of the GAO for hearing?
Well, with regard to the GAO in general, you have to understand that they started the hearing predictably as a result of GSBCA, and they're kind of more of a court approach to handling things, and GAO decided that they could do that too. But the history of GAO was primarily one of conferences where folks would sit around a table and they would discuss the issues and discuss what had taken place. And if the truth is known, the hearing, as it were, that the GAO has is not much more than a conference, which effectively has that informal element that you wouldn't expect in a BCA case or a federal court case. It is very much driven by what the GAO attorney wants to raise. They ask specific questions. And the thing that may surprise a lot of folks is that quite often they're involved with hearsay. In other words, what I normally tell a board is anything that goes on in a dialogue with regard to the evaluation or how you do things, someone can say, what was the approach? How did you do this? What did they say? And that will go in front of the GAO attorney. Now, one of the critical things that everybody worries about as a lawyer, the judge or GAO attorney becomes kind of an advocate for their opinion, and they're not going to build their case on hearsay evidence exclusively or even necessarily mention it, but it can influence the outcome of the case, at least in my opinion, and they may ultimately build in other areas. But if they feel that for whatever reason the hearsay indicates that it was other than fair, other than equitable, or adhering to the stated evaluation criteria, they might go hang their hat somewhere else and speak to the law as we all know it. So you got to be very, very careful in how you handle a GAO hearing. It's just, as I tell folks, you're in a glass house when you're doing that evaluation, and everything you say and do, somebody else can be bringing it up at a hearing, and you may find that ultimately it influences the outcome.
Yep, that I would tag on to that with Bob. First of all, generally speaking, from the government's point of view, if the GAO wants a hearing, that's not good news for us. More often than not, I think we're going to lose those cases. Now, since my time at NASA, I've only had one hearing, and that was on it was a NASA-wide contract for the security services. We'd already gone through one protest that we had lost at the Court of Federal Claims. That had been run by another center, and it was then given to Langley to run. We had this protest, and one of the things that you need to understand is that if you're going to a hearing, you've got to treat it sort of like a trial, which means in addition to all of the, I'll call them pleadings, the agency report and the legal memo and the CO statement of fact, you now need to prep your witnesses. So you need to run them through a direct exam question set. And then you need, I think it's very important, you need to run them through cross-examination. You need to get them to understand the kinds of questions that they're likely to be asked by the other side. When we had that case, we had 4 attorneys working on the hearing, at least 4. There may have been a 5th at the headquarters. One attorney went up to work with the SSA. Another
Seems like a
attorney
lot for the witnesses to prep for.
It is, and we had 2 attorneys down at Langley, and we were prepping the SEB chair, and we spent 2 days with her, running her through question sets. And when we started going through the cross-examination, we had her pretty well flummoxed by the end, which is really good because it gives her a sense of, okay, here's the kind of questions you're going to get, and here's how you ought to be trying to handle those questions. So she was superbly prepared, and I think that impressed the GAO attorney. Bob was talking about how the GAO attorney is going to go kind of, I almost say with his gut. Going back to my days in law school with a professor that Bob may have heard of called Ralph Nash, one of the things that he used to say was, you need to make the judge cry. This was in my first year courses. You need to make the judge cry, and the judge will then find a way legally to come to the decision that you want him to come to. So that's what you need to do. You need to be well prepared. You need to show confidence in front of that GAO attorney so that the GAO attorney understands, yeah, they did their homework. They know what they're talking about. And as Bob pointed out, documentation is everything in a GAO decision. That's why we're always insisting on documentation. So we won that case. Now we've had cases when I was in the Air Force, and there were often times where this was when the General Counsel's office was responsible for handling GAO protests, even though the field centers and attorneys had a major role. But when we often got requests for hearings, as often as not, the General Counsel said, let's take corrective action, because they were afraid we were going to lose the case. So those are the kinds of things that I've seen. There's a lot of preparation to get ready. The hearing can go a few hours, it can go a few days. Generally, I think they generally run a day or so, but you really need to be prepared. And you got to understand that the rules of evidence don't apply. The GAO attorney is going to be as active as the attorneys for both sides are, unlike in a court hearing, usually, where the judge is usually not as active.
Now, we've talked a lot about witness prep and getting ready for the hearing that way. I'd like to come back again and talk to you a little bit about the document preparation for a hearing, or even the preparation that goes into the initial agency filing at the end of the 30 days. What type of case law should we use? How should this be structured? Do you mind coming back again and talking to us a little bit about that?
Sure.
See you next time between 2 FARS.